Ms Legalista, aka Attorney Sheila here. Sometimes you get caught, sometimes you don't. I don't know if I want to consider this like clout chasing by DJ Envy to try to use the Coachella brand for his own. I mean, I get it, but you're infringing probably on someone's trademark when you try to take their logo, their design, and tweak it for something you're trying to do. It's probably going to get you a cease and desist letter, and in this case, a lawsuit. So let me pull this up so we can actually take a look at this lawsuit between Coachella and DJ Envy or Raashaun Casey regarding his use of Coachella. Coachella is the name of it. And let's see if I can make this a little bit bigger. Okay, Coachella. So this is coming out of New Jersey. Here's the nature of the action. Okay, trademark infringement and false designation of origin under state and common law trademark infringement, and then also unfair competition. Yes, and they say that these are registered trademarks and service marks. All right, let's get a little bit more into this. Yeah, let's touch on this part right here before I get into their little narrative, because I always like the narrative. Held annually, plaintiffs Coachella Valley Music and Arts Festival, Coachella, is one of the most critically acclaimed music festivals in the world. With multiple bands, artists, food vendors, and stages, Coachella is a sold out event which attracts hundreds of thousands of attendees to Southern California each April. Intentionally trading on the goodwill of plaintiffs' famous Coachella festival, defendants are attempting to operate their own car themed event, which prominently features live music named Carchella. So you can see how people might get a little confused about that. The Carchella event uses a mark with identical stylization as that of Coachella. The stylized Carchella mark, as used by defendants in their promotional video posted on defendants' social media accounts, and the stylized Coachella mark used are both depicted below. So look at this. Look, I mean, so first of all, you're using the whole Ella at the end. You've got the CHella, okay, because you took most of it. The only letters that are different are the first, or not even the first three. It's those two. It's the AR and the OA. Carchella, Coachella, okay? Only two letters that are different there. And then what they're saying is you're using the same style, the font, this sort of, I don't know what you call it, but you can look at it and see there that it's the same. Even though the colors are different, it's the same style. Now, before I even go further, the rule, of course, the rule is this going to cause confusion in the marketplace? That's always, the thing to consider when you're talking about infringement. Are people going to wonder, or people going to automatically think that this is part of Coachella? Well, if you see Coachella and then you see this Carchella name, you might associate it with it, especially if it's another like themed event with live music and celebrities. Then yeah, I could see how there could be confusion in the marketplace. It says, like plaintiff's famous Coachella Festival, defendant's Carchella event features numerous forms of music and entertainment. See, what did I tell you? Defendant's first two Carchella events were held in Atlanta and Atlantic City. Additionally, defendants are advertising events in Detroit and Miami. Plaintiffs have no objection to defendants holding their events, but defendants must adopt and use an event name and mark that avoid a likelihood of consumer confusion. What did I just say? Confusion in the marketplace and false association with plaintiffs' Coachella Festival, and the Coachella marks. Despite repeated requests, what did I tell you? Usually they start with a cease and desist letter. Defendants have refused to adopt their own distinctive event name and mark. Accordingly, plaintiffs have been forced to file this action to protect the Coachella trademarks and service marks from infringement and to protect the public from the likelihood of confusion and false association caused by defendants. So then you have the parties here. Coachella Golden Voice, which I think is like the company producing the festival. Then you have Raashaun Casey, aka DJ Envy, and then his actual company, and then DJ Envy Auto LLC. All right. And then here's the background, the backstory. Let's go into the backstory. Plaintiffs own and produce Coachella, one of the country's premier music and arts festivals. Printouts of several news stories about Coachella are attached to this complaint as Exhibit 1. The caption from one photograph accompanying a story from CNN reads, "An aerial view taken from a helicopter on Sunday shows how big the 2011 festival is. Held annually at the 78-acre Empire Polo Club in beautiful Southern California desert, Coachella is one of the most critically acclaimed music festivals in the world. First held in October 1999, drew some 25,000 attendees. Over the years, the attendance and prominence have grown. Attendance to the sold-out Coachella Festival, aggregated over the multi-day event, is estimated at 750,000 attendees. That's a lot of people. For the past several years, when the festival has been held, tickets to Coachella sell out. And for the past few years, typically sell out in about an hour. That's fast. Tickets for the forthcoming 2022 Coachella Festival have already sold out as well. Printouts of several news stories about Coachella selling out are attached. Coachella mixes some of the most groundbreaking artists from all genres of music, along with a substantial selection of art installations from all over the world. Coachella attracts some of the world's biggest megastars to perform. A list of the artists who have performed include Beyonce, Beastie Boys, Bjork, Coldplay, Daft Punk, Depeche Mode, Drake, Jane's Addiction, Jay-Z, Kanye West, Madonna, Nine Inch Nails, Oasis, Paul McCartney, Prince, Radiohead, Rage Against the Machine, Red Hot Chili Peppers, Roger Waters, The Cure, the Pixies, and Tool, to list only a few. Okay, well, that was a lot. Coachella is about more than just music. The festival's venue also includes camping facilities for some 15,000 attendees, complete with a karaoke lounge, and a general store, and an amazing selection of food and beverages from a wide range of restaurants. The festival also features an extensive art exhibit, which includes many pieces of art, including sculpture and so-called interactive art. The music, the food, the art, and of course, the fellowship of other attendees taken together make Coachella more than just a concert to attend. It truly is an experience. Coachella frequently includes exhibits of cars at the festivals. See, I didn't know that. Photographs of Coachella car exhibitions are attached to this complaint. Now, that makes it even more likely that there might be some confusion in the marketplace. Plaintiffs own and operate Coachella's website, available at www.coachella.com. This website has received over 20 million page views in 2019 and hosted nearly 8.5 million users over nearly 12 million sessions. Screen captures, are attached to the complaint. Plaintiffs also produce a mobile app for Coachella for use on iPhone and iPad and Android devices. Plaintiffs extensively promote their Coachella Festival through a variety of media, including via the internet on its website and on numerous social media sites, including Facebook, Twitter, and Instagram, to list a few. And then they've got some screen captures there, and they tell you how many likes and how many followers, Instagram users up here. It says plaintiffs invested over $1 million in 2019 alone in media and related content to promote Coachella. An internet search of the term Coachella Music Festival provided over 1 million hits. Let's go down and see what else. They've gotten 130 million impressions, and that's just from March to May 2019. Over 500 credentialed journalists from print media, radio, television, and the internet reported live from the 2019 Coachella Festival. The journalists represented media outlets as diverse as Time, Billboard, and the BBC. It says the plaintiffs own the exclusive trademark and service mark rights to the distinctive Coachella trademark and service mark, having used the mark in connection with the festival and related goods and services since the first Coachella Festival in 1999. Similarly, plaintiffs own the exclusive trademark and service mark rights to the distinctive, look at that, stylized trademark and service mark, having used the mark in connection with the festival and related goods since the first festival in 1999. And then you see the depiction there. So they keep going on with that. Yes, we know, same sort of thing. It talks about during the pandemic, And again, they've got versions of it: Coachella, Coachella Stylized, Cella, Coachella, Coachella, Valley Music and Arts Festival. So those are just some of the marks that they have listed there. It says, as a result of plaintiffs' efforts and use, the Coachella marks have come to be recognized by the public and members of the trade as being associated exclusively with plaintiffs and Coachella. Plaintiffs have entered into a very limited number of highly sought after licenses to use the Coachella marks. They have some official sponsorships. Several sponsorships have been with leading car manufacturers. Again, so this is where this confusion in the marketplace comes in. And so they're definitely trying to protect this. And so then they have a listing of their trademarks. You can see all of these listed here, registration certificates. And then they talk about the defendant. This would be DJ Envy. Defendants operate and intend to operate a car-themed entertainment events named Coachella and using the mark Coachella. Car exhibitions have been a core component of previous Coachella festivals, with a BMW exhibition in 2017 and Hyundai exhibitions in 2011 and 2012. This is music as a primary component, but it says that festival features same or similar genres of music. All right, so then let's talk about Casey. Defendant Casey is a well-known disc jockey specializing in rap and hip-hop music. Rap and hip-hop music are performed at Coachella, and consumers who enjoy rap and hip-hop music attend Coachella. Defendant Casey's advertising of Coachella through the DJ Envy Instagram page directly competes with the Coachella Festival's fan base, as rap and hip-hop are some of the primary genres played at Coachella festivals. Additionally, defendants prominently identify various celebrity guests whose cars will be exhibited at Coachella events. These celebrities include music artists 2 Chainz, 50 Cent, French Montana, and Lil Uzi. Each one of these artists has previously performed at Coachella, and then they list the years there. All right, and what else do they say? Defendants use the DJ Envy Instagram page to advertise Coachella events, including using hashtag Coachella. It says they have, according to the Coachella 7days7nights.com webpage, the Coachella Festival will feature music rides, carnival games, and cars. And then they have who from again. And all this is on the Instagram page. It says there's going to be a fee. It says defendants have also displayed on their promotional materials Coachella in the same distinctive font as Coachella. Defendants also use Coachella on their social media accounts and their handles. The Coachella Festival is marketed to the same or similar customers. This is what you're trying to do. You're trying to show overlap, that we're appealing to the same people. That's why these people are going to be confused. They all like hip hop. They all like celebrities. They all like cars. And then you throw in our names. You took our name that's kind of similar or something similar to our name. Yeah, so they're trying to show how people could be easily confused and associate these together. Defendants have gone to great lengths to imitate Coachella. Like Coachella, the Coachella Festival is an outdoor event featuring music and art. Defendants are not affiliated with plaintiffs or Coachella. Defendants are not licensed to use the Coachella marks. Defendants had constructive notice because these marks are registered. It says defendants' use of Coachella to market their festival was done with actual knowledge of the Coachella marks, meaning they knew about this. Defendants adopted and used Coachella to market their festival because it is similar to the Coachella marks. See what they're alleging? That they did this on purpose. And a lot of times we do things, we see things that we like. Okay, it's flattery. It's the whole I like that. I want to do something like that. But you can cross a line at a certain point and infringe on someone else's property rights. And that's what they're alleging here. We get it, you like us, but that doesn't mean you get to take our stuff and use it in a way that it benefits you at our expense. So it says, defendants continue to advertise and promote the Coachella Festival even after receipt of this cease and desist letter. What did I tell you? I told you in the beginning. DJ Envy LLC has also applied to register Coachella as a trademark and service mark. Plaintiffs have repeatedly requested that DJ Envy LLC abandon its trademark and service mark applications for Coachella and that it and its co-defendants cease all use of Coachella or any similar designation, but it and its co-defendants have refused to do so. So then here's where they're going. This is what I said. Defendants' unauthorized use of the Coachella or any similar designation thereto creates a likelihood of confusion as to the source, sponsorship, affiliation, or endorsement of defendants' event and is likely to falsely suggest a sponsorship connection, license, or association. So, yeah. And so you've got the counts here: infringement of trademark. So basically, trademark infringement there. And then you've got count 2, trademark and service mark infringement. And again, you've heard the facts there. In New Jersey, they're using a state law here, New Jersey's unfair competition law, and then also New Jersey's trademark infringement law. Then we've got common law infringement and unfair competition. And then that's pretty much it. And they're asking for a jury trial. All right. So that sort of sums that up. So you get to see what they were alleging in that and how that all came to be. So hopefully that gives you some idea, if you're looking at something and you think you like it and you want to do something like it, sit down with an attorney, make sure you get that right. Remember the whole McDonald's, I can't even remember the name of the restaurant in Coming to America. But remember how he was saying, they have this, I have that, they have this, I have that. And they were trying to shut him down. Okay, well, yeah, this is sort of similar to that. You can't take somebody else's property, and in this case, their trademark or service mark, and then sort of tweak it for your own use. That's probably not gonna work. All right, don't forget to give the video a thumbs up. Don't forget to hit the notification bell. Peace.